A person could point out, like I said at the beginning, a lot of violations because it's impossible to do everything perfectly. So what a court would really be looking at, not that they didn't ratify a decision according to the bylaws or something, they would be looking at, was there also harm? So if you don't give proper notice, I think a court would say that they would have to redo the meeting. But other, let's call them more technical, minor violations of covenants, a court probably would not give any relief.
HOA Insights, common sense for common areas, exists to help all 2 million volunteer board members nationwide have the right information at the right time to make the right decisions for their future. This podcast is sponsored by 4 companies that care about board members: Association Insights and Marketplace, Association Reserves, Community Financials, and Kevin Davis Insurance Services. You'll find links to their websites and social media in the show notes.
Welcome back to HOA Insights, common sense for common areas. I'm Robert Nordlund, and I'm here with a special guest to talk about what to do when the board does wrong. Well, if you missed any other prior episodes, take a moment at the end of the program to subscribe to this podcast on any of the most popular podcast platforms. You can also listen from our podcast website, www.hoainsights.org, or watch on our YouTube channel. And if you have a hot topic, crazy story, or a question you'd like to have us address, leave us a voicemail message at 805-203-3130, or send us an email at podcast@reservestudy.com. Well, today we have a special program in store for you. We had a listener write in about a problem they were having with their Georgia Condominium Association. More on that later. And we reached out to a prominent Georgia attorney in my network of friends to get an expert opinion on the issue. I thought he'd share a few minutes of encouragement or advice, and we'd be back to one of our regular episodes with one of our co-hosts. That short answer turned into an extended discussion, and I think you'll enjoy the conversation. It all started with an audience question that went as follows. Dear Robert, your recent episode number 32 had me wondering what you think about the other side of the topic. I was a secretary of my HOA for a little over 2 years before I resigned due to the lack of a safe, controlled environment where the board members weren't attacking each other. In addition, I feared my liability exposure because some board members refused to follow the proper procedures or abide by state laws and governing documents. We have all the rules and regulations right here in our governing documents. However, some board members, some of whom have been on the board for over 30 years, refuse to do their due diligence or have knowledge of the process and make up rules even after being shown where it was written. No parliamentary process was or is being followed, even though this was required by bylaws in 2017. After resigning, I attended the first annual HOA meeting where the notification of this meeting was in violation due to only giving owners 4 days' notice. I wrote the new president of the association and shared this information with him, and he did not respond. Then, at the meeting where I mentioned it and suggested that we should reschedule to allow more involvement from neighbors who wanted to attend the meeting on the grounds of insufficient notice, I was just told no. So in short, I've tried to help this board get on the right track, and I've given them factual proof that they are not abiding by Georgia law or our governing documents. So what are our next steps? Well, we thought this question described an all too common situation where there's a minority board member not seeing eye to eye with the rest of the board who are resistant to change. So I reached out to George Nowack, founding partner with the prominent Georgia Community Association law firm Nowack Howard. I've had the privilege to work with George through the years on a number of projects, and it's always been a time where I appreciated his wisdom and his knowledge. You can get in touch with George or his other staff attorneys at Nowack Howard at, simply enough, nowackhoward.com. That's NOWACKHOWARD.com. So George, welcome to the program.
Robert, thank you. It's a real pleasure.
So help me here. What does a person in this situation do?
Well, Heather's question and description of her issues it's interesting initially from the standpoint in that her concern was both experienced as a member of the board, and that concern is continuing now that she is no longer on the board of directors. And the overview of the issues in her questions has to do with members of the board of directors, the majority of the board of directors, apparently not following the declaration, the bylaws, the rules and regulations, the articles of incorporation, and like most states in Georgia, the associations are incorporated as nonprofit corporations, so there's also the Georgia Nonprofit Corporate Code. That code is pretty standard in most states.
So plenty of rights and wrongs, things to do, things to follow, and this person is aware of all that's not being done well.
Yeah, shortcomings in following, and I'm going to use the word all of the provisions of the governing documents. I say all because let's be realistic. It is impossible for a board of directors to follow all documents to the letter. Declaration, bylaws, rules, regulations, articles of incorporation, etc. And the issue that I'm seeing in the question and the request for help is some are procedural, like where it's mentioned that notice of an annual meeting or a board meeting, I couldn't tell, was improperly given, and the suggestion that it be reconducted. There's also a comment about the board not following Robert's Rules of Order. So Heather wants the association and the board to live by the written documents. And when it comes to, first of all, Robert's Rules of Order, it's very interesting. Most people don't read the introduction to Robert's Rules of Order. I guess I'm one of those strange guys who have read the introduction to Robert's Rules of Order many times.
Yeah. Well, do you have Jim Slaughter's book on the? Yeah. Okay.
Yes. And also the full one.
Yeah, and I've got his book on my bookshelf here, and we had him as a guest earlier in one of our podcast episodes.
Oh, okay. I've got his books also. And what Robert's Rules talks about is deliberative societies. As it indicates, it was designed to be an authoritative manual on how to conduct business at deliberative bodies. Well, it's also applied many times to the boards of directors of corporations with associations being nonprofit corporations. But what Roberts says is it's not intended, and I'm paraphrasing, to be obstructionist. It's designed to provide order and avoid chaos in mass assemblies. But the thing that I like about it, among many other things, is that it says it's really not intended to apply in its entirety or the majority of it for boards of directors of less than 12 people.
Ah, interesting.
Okay. And so it goes through, if you try, again, I'm paraphrasing, but if you tried to follow Robert's Rules of Order with the small boards of directors that we're most familiar with, you really wouldn't get anything done. Let's be realistic. We need some rules of order, but it's for these bigger deliberative societies. In these smaller boards, you have to act practically, is really what Roberts is saying. So I've been involved for 43 years with representing associations, and a specialist in Robert's Rules of Order I've seen several times try to completely destroy meetings. The other side of it is if you don't have any order, obviously you have chaos. So let's boil it down. You have a board of directors, let's say, of 5 people, which is what I see the most. You have a president, sometimes you have a vice president, you have a secretary, treasurer, but there's a board of 5. President usually is the chief operating officer, presides at all meetings, and in the absence, the vice president, et cetera. Well, what is preside and what does all that mean? It means that the president typically sets the agenda, presents the information, calls upon other people to present information, and conduct business. Making motions is relevant, but getting into amending whether or not it's a question of privilege, whether or not there are, and you could go through the whole list of Robert's Rules of Procedure in a small meeting and really not get anything done. So when Heather says they're not, that they agreed to live by Robert's Rules of Procedure, or the amendment did, we got to be practical. And just because somebody didn't make a sub motion to a main motion or whatever, yeah, it may be a violation, but it's not really practical to live by Robert's Rules in small boards of directors. So there's that matter. There's the matter of not following procedure, what I get from this, both when she was on the board and now that she is off the board of directors. And procedure is important, especially when it comes to giving proper notice and conducting meetings in accordance with the procedures that might be stated in the documents. Most documents require 21 days notice of an annual meeting and 7 days notice of a special meeting, at least in Georgia. Well, the notice requirements are those dates which the legislature in Georgia decided were reasonable times to enable people to have notice of and be able to attend, if they so chose, regular annual meetings of the members or special meetings of the members. And it's important to follow those. Anyone has the right, if they believe notice has been given improperly, to show up at a meeting or attend by Zoom and start. As soon as a meeting is called to order, the person would say, I want to bring a point of order, or I want to raise an issue. Notice was supposed to have been given 21 days in advance, and we all know it was only given 4 days. I object to the notice. Well, if somebody does that at the beginning of a meeting, you can't wait to the end of the meeting, and you can't wait until there's a vote you don't like. Right. You have to state at the beginning that the notice was improper. And if that happens, the best advice I would give any client of mine would be, if it clearly was not 21 days, then the motion or the notice that the notice was improper should be considered very seriously, and I would tell my client not to proceed. And let's go with, she raised it at the beginning of the meeting and the board ignored her. Let's just play it out that way. Well, could she raise it as an issue? The answer is obviously yes. But first of all, challenging that would be what's known as a derivative action, which most people don't realize. And when I saw this question, I was excited that I'd be able to explain derivative actions, because it also said, what can I do, or where do I go in my next step?
Which is exactly why we have you on the program.
Well, thank you. And most people have heard of derivative actions when it comes to stock corporations. Probably the most famous one that I can remember, but I guess it's getting old at this point, is the Enron scandal with Texas. And all of the money, or there was a mobile telephone conglomerate, the same thing, where the board of directors and the chief operating officers were committing fraud against the shareholders. And when you are on a board of directors of a profit corporation, you have a lot more responsibility for the operation, of the corporation. And when you feel that you have been wronged in a stock corporation, a stockholder cannot bring a lawsuit against the corporation. It's called a derivative action, and it requires a certain number of stockholders to sue the corporation and the individual members of the board of directors for wrongdoing. Well, that same concept or that same process applies, again, in every state that I'm aware of with the model nonprofit code. And here's how it works. Heather's saying that business was not conducted properly. Well, that's not a harm against her. It's a harm against the corporation.
Okay.
So just like if the stockholder money was stolen, it's a harm against the corporation, not you as an individual stockholder. So a derivative action is just that, where in Georgia and again in most states, 50 members of the corporation or 5% of the members, whichever is less, have to bring a lawsuit, a derivative action. And it's not just one person who's the named plaintiff and people give money to support it because they feel they've been wronged also. When I say the number of people, you have to actually be a plaintiff. And what you're doing would be suing to say that the board of directors did not follow the process. It's not living up to the declaration, the bylaws, all the things that Heather has said. And you have to, first of all, get those people. Then before you actually file the lawsuit, most states that require you have to send a very detailed letter to the board and the members of the board, explaining in detail what they have done wrong and giving them the opportunity to cure it. And they can respond during those 60 days or they can ignore you. And if they don't agree to fix it or they ignore you, then after that 60 days, you file this thing called a derivative action. And you allege the things that you believe that the corporation and the board have done wrong, and you ask the court to order them to correct it. So here it would be following state law, the declaration, and the bylaws. But let me put this caution in there. A person could point out, like I said at the beginning, a lot of violations because it's impossible to do everything perfectly. So what a court would really be looking at, not that they didn't ratify a decision according to the bylaws or something, they would be looking at, was there also harm? So if you don't give proper notice, I think a court would say that they would have to redo the meeting. But other, let's call them more technical, minor violations of covenants, a court probably would not give any relief.
Because these are volunteer board members. Yeah.
They're volunteer board members. And unless they are knowingly and intentionally not following the documents, which always is a matter of proof, as opposed to, I made an honest mistake.
Got it.
Okay. I'm not a lawyer. I'm not a manager. I'm not fill in the blank. And Robert, if you and I've heard this once, it's got to be close to millions with the two of us. You know, I'm only a volunteer.
Right. Right. Well, that's the purpose of what we're trying to do here. It's an interesting question about a minority board member who didn't feel comfortable as a board member, stepped into the homeowner role. I appreciated you setting the stage by saying it's very difficult to be perfect. And when I think of perfect and humans, I think that's oil and water. Don't mix. And then you add volunteer humans, and we have to say, I am so thankful the board is even serving. I'm comfortable with imperfect. So is this an issue of we have to lower our expectations for what a board member can be expected to do? It can become overwhelming if they're trying to be perfect.
I'll be careful how I say this, but I'll be direct. I don't know of a board that tries to be perfect. I think my average client attempts to do the best that they can do, which is a cliche, but they do in the best they can do. And what I want to stress with what I said a moment or two ago, it's the knowing and intentional failure to abide by the covenants and state laws that is really more of the problem in what Heather is asking, as opposed to either an honest mistake or go back to something I always said, them being practical. I mean, I certainly get a lot of questions like this where the board didn't do, you fill in the blank.
Right.
And what I normally say to the client, first of all, is if it's the board and they didn't do it intentionally, they're panicking because they made an honest mistake. The first thing I always say is relax. Relax. Whatever you did or didn't do, you're not going to jail, and it can be fixed no matter what it is. If we have to hold another meeting, we hold another meeting. But let's also look at, okay, you didn't do that, but what is the harm? What is someone going to sue you for? Let's say that in Heather's case, forgetting that she needs to bring a derivative action, let's just say that she sues herself saying they only gave 4 days notice. Well, it's going to cost her money, but then a judge is going to say, okay, what is the harm? Or let me give you a better example, which we all see every year at this time with annual meetings. We don't get a quorum, or we don't get enough people to run for the board of directors.
Right.
But in either case, we're not perpetuating the election cycle. And I've had people say, well, I'm going to sue the board of directors because they didn't conduct the election properly. And you say, okay, what did they do wrong? Well, they didn't nominate enough people to fill the vacancies. So let me get this straight, plaintiff. You're suing the board for not conducting the election properly because there were 4 seats vacant, but we only got 3 people. That's right. And I always want to say to the person, well, you know, when you go before the judge is going to ask, well, did you nominate yourself? Did you volunteer to fill in and follow the bylaws? No, I'm too busy. And the court's going to say to them, first of all, you're wasting my time.
Yep.
And second of all, where's the harm? And that's when you hear the person say, it's not a matter of harm. It's they didn't do it correctly. That's when the judge says, thank you for sharing. Goodbye.
Yeah.
So you always have to look at what was the error. And if what is one, like I said, that we have to start the annual meeting notice over, we do. We don't fight major mistakes, but if they're innocent, minor mistakes, and there's really no harm, then that's another way of looking at it, to where we try to console the person who is not happy, but at the same time, support the integrity of the board of directors in making an honest mistake.
Hi, I'm Kevin Davis, the president of Kevin Davis Insurance Services. Our experienced team of underwriters will help you when you get that declination. We provide the voice of reason, someone who will stand by you. Our underwriters bring years of knowledge to our clients that can't be automated by technology or driven by price. As a proud Anwins company, we bring true value to your community association clients. We are your community association insurance experts.
Yeah, what I'm writing notes down here. Don't focus on errors. People are going to be imperfect. The board has a heck of a challenge to do the budget, pay the bills, collect assessments. Even with management help, they're making decisions all the time. And it's just plain a hard job. And our listeners know this. And I guess our counsel here to the minority board members who see wrongs happening around them, maybe we're asking them to put on a different color lens and see what good is happening, and asking them to participate in the good and carry the burden for moving the association forward rather than nitpicking the wrongs. Is that kind of where we're going?
That's
okay.
Exactly right. I do a talk. The heading is, you can take that position, but. Okay? And you go through scenarios like this and you say, you can take that position, but. Now let's look at the impact on the association. Nothing or something or great. You can take that position, but do you realize how much it will cost the association to do something or to undo something? And is it of that serious of a nature? Are we arguing, well, you didn't do it exactly? We're getting back to that. So yeah, you can take that position, but think of the consequences. And there could be monetary, but more than that these days, it's the emotional toll. And
well, it's a time and the distraction. The board has a hard job to do. And in your words, let's call it an honest mistake. Darn, we forgot. We just plain forgot to put the announcement out, or my computer was down, or whatever it was. And we have a full room here. Yeah, we didn't notify people, but we put it on the bulletin board. Everyone got, we have a pretty good full house. We can notify things. We're moving the association forward. We're imperfect. Sorry, folks, we'll do better next year. And we can move on. I guess one thing I feel in my heart is lower the temperature. Imperfection is all around us. The janitor is going to forget to empty one wastebasket. The landscaper is going to miss that sprinkler hadn't been functioning and a plant dies. What can we do to help the association move forward? Is that our encouragement here? How can we help?
It is. And the whole idea of lowering the temperature One thing that the pandemic caused, and I'm sure you've talked about this with Kevin Davis and other folks, is the number of complaints that have been filed against boards of directors for not doing things exactly. They didn't go after John because he left his trash cans out a day and a half longer than the rules say. And this is all from people being at home when they normally weren't at home.
Right.
But the other thing that was already building, but in my opinion has gotten totally unrealistic, is the use of Facebook, email, you name it, next door neighbor, or whatever, all those platforms, and the viciousness of the attacks on the board of directors for making honest mistakes. The best way to describe it is out of 600 houses, there's maybe 50 homeowners who do not like the current board of directors. And no matter what the board does, it's always wrong. And I'll give a quick example. They just recently had an election of directors. And under their documents, the nominating committee runs the election and counts the ballots. So you could vote electronically, but they also had the old-fashioned ballot box with the little slit in the top.
Right. I like that.
Padlock on the front of it. But, just everything you can picture.
Makes you feel like you're voting.
Yes. And the deal with the nominating committee was there were two padlocks, and there were two people who had keys, each one a different key. So they had to work together to open the ballot box.
Sounds like the nuclear launch codes.
There you go. And so one of the members of the board who was under constant attack had a suspicion that he needed to put one of those game cameras that click a picture every time something moves.
Right.
And he put it in the eaves of the clubhouse. And they caught, with over 700 photographs, they caught the chairman of the nominating committee opening the ballot box. He had both keys. And rifling through the ballots. He took at least one because he stuck it in his back pocket, which was going right to the camera.
Yep.
And on the day they were supposed to count them, they showed it to him. He first denied it, and then he said, well, the reason he did it was because he had voted improperly and he was fixing his ballot.
Okay.
And we then said, well, you've tainted, you've compromised the election. So the board declared the election void. We didn't even count the ballots. And this is where I'm going to show some frustration. It went from ballot tampering to he is the most honest guy in the world. The board set him up by putting that camera in the eaves of and this group he has got to count the ballots because he's the only one qualified. The board is the one who created this mess. And that's where I'm having a hard time really understanding. I would hope most people would see that as ballot tampering. It doesn't matter whether it was one ballot, right? Or 50.
Right.
It was tampered with. But the viciousness of the attacks on these board members over something that is black and white. I mean, I even read one that said, when he explained that he was correcting his ballot, someone wrote, I knew there was a second side to that story. No, there's not a second side to that story. There is no story. My point being, lowering the temperature is almost impossible these days if you're using the internet to say whatever you want, accusing people of things. But the other thing that the internet has done, Robert, I can say the most outlandish thing about you, and I don't have to prove it. You have to disprove it. And that's the problem. The board, how do I disprove all of these allegations as a board member?
Yeah.
The other thing is, if you don't want to get into a derivative action and you believe that you can show folks in your community that things need to change, then you either control the election at the next annual meeting, or you follow the process and remove one or more or all of the members of the board and replace them. Derivative is expensive and it takes time. Getting rid of those people that you do not believe are doing their job properly, or you know they're doing it improperly, then you've got to convince enough members in the community to support a recall or get them out of office next time. If not, we're not saying that you're not justified in the way you feel, but you do not have the support of the members in the narrative with someone saying, and there's a person who's been on the board for 30 years, that always throws up all right, time out. You've got somebody who's been on the board for 30 years. Well, those people are entrenched. And when you say, again, in the question, that bringing matters to the attention of the old guard is not met with a lot of enthusiasm. Of course it's not. You're the new person. You're the one who's coming in. It's like being a freshman in the United States Congress or House and wanting to be the Speaker of the House right away. It's not going to be received real well. And why do people keep electing that person?
Yeah.
Well, I think we know. Nobody else wants to do it.
Yeah. On one hand, I'm thinking a 30-year board member should be revered. Boy, the countless hours they've put in to move the association forward. Yet that board member can't do it themselves. They need to have fresh blood. They need to have elections with fresh people that can add to committees. Hopefully they have a strong committee structure that can be a pipeline of new board members who can come in with help about the new legislation, new insurance requirements, new whatever it is, and help shoulder the load, because it is a heavy load to be a board member and you can't do it yourself. It is largely a thankless job. And again, the reason for this podcast is to help community association board members see that there's others out there. And the encouragement I'm getting out of this one is appreciating that perfect is unattainable. So let's not focus on the nitpicking, because it can be found anywhere. It can be found in our lives. George, it can be found in our lives. And if we can focus on...
Well, maybe yours.
Well, yeah, you know me. How do we move the association forward? How can, I guess what my heart of hearts is saying is change my attitude from what is wrong to how can I help?
But that goes back to what we were just talking about with getting the support of the rest of the members. Again, we're not discounting the way someone feels when they raise issues like this. But if you do not have others in the community who feel the way you do, taking out the rancor and things that people say, but just bottom lining it, you're not going to get anywhere, and you're going to get very frustrated, because the alternatives are the recall or the derivative action. Yeah. And we went through, and we still are going through, periods when associations are running well, and when I say running well, normally it's because we're talking about financially, when they're running well, dues don't go up or they only go up a modest amount, then you don't have really anybody who wants to be on the board of directors. And so complacency fits in like a 30-year board member.
Right.
And so again, getting the support of people behind you, it's sort of, the boat is floating perfectly well. So why would I want to rock the boat?
Right. Well, you add the pressures of the last few years of the pandemic, the higher inflation, insurance increases, a little bit of scare from Champlain Towers South, and all of a sudden you have unsettled communities. And what do we do? But we want to help associations move forward, and that means shouldering the load and finding where you can help, and not creating more problems for the board to deal with.
Correct. If people can remember this podcast for no other reason, remember, you can take that position, but.
I like that. I think that's the theme. Well, George, it's been fantastic to have you on the program today. Just a fascinating discussion on communities in general, board members, homeowner actions, and so much more. And again, if you want to get in touch with George or any of the other attorneys at Nowack Howard, you can reach them at nowackhoward.com, NOWACKHOWARD.com. George, thank you again for being on the program.
Robert, I can't thank you enough for giving me this opportunity. Thank you.
Well, we hope you learned some HOA insights from our discussion today that helps you bring common sense to your common areas. We look forward to having you join us for another great episode next week.
You've been listening to HOA Insights, Common Sense for Common Areas. You can listen to the show on our podcast website, hoainsights.org, or subscribe on any of the most popular podcast platforms. You can also watch the show on our YouTube channel. Check the show notes for helpful links. If you like the show and want to support the work we do, you can do so in a number of ways. The most important thing that you can do is engage in the conversation. Leave a question in the comment section on our YouTube videos. You can also email your questions or voice memos to podcast@reservestudy.com or leave us a voicemail at 805-203-3130. If you gain any insights from the show, please do us a huge favor by sharing the show with other board members that you know. You can also support us by supporting the brands that support this program. Please remember that the views and opinions expressed by the podcast do not constitute legal advice. You'll want to consult your own legal counsel before making any important decisions. Finally, this podcast was expertly mixed and mastered by Stokelight Video and Marketing. With Stokelight on your team, you'll reach more customers with marketing expertise that inspires action. See the show notes to connect with Stokelight.